workplace privacy, employee monitoring, and North Carolina law. HR professionals handle protected, personally identifiable information and private health information on a daily basis. They also wield the power to investigate employee conduct and snoop on employees' workplace activity through access to company email and security systems. However, with this power comes a lot of confidentiality questions, and many employers have reached out to me lately about various employee privacy concerns. So let's tackle a couple of those now. Scenario 1. You find out a newly terminated employee has been sending personally identifiable employee information, like social security numbers, dates of birth, etc., to his personal email address. You are concerned about this data breach. What should your organization do? Resolution. In North Carolina, the Identity Theft Protection Act provides certain protections and requires certain actions from employers in the event of breaches. If necessary, employers should report the breach to local law enforcement and through the NC Department of Justice's website. You also must provide notice to the affected employees. Scenario 2. Your employee, Frankie Fightstarter, has been having major performance issues. Coworkers complain that he is operating a personal business during company time using company assets. Frankie's coworker even submits a recording she made on her cell phone of a conversation she had with Frankie about his work on this business while on the job. You speak to Frankie and he admits nothing. So, per your company policies, you review security video footage of Frankie's open seating work area, the coworker's mobile recording, and Frankie's company email for evidence of these activities. When confronted with the evidence found during your investigation, Frankie becomes livid and says the company has violated his privacy by utilizing these various methods. But did the company actually do anything illegal? Resolution. In North Carolina, Frankie's coworker, as a party to the conversation, was within her right to record their conversation, as North Carolina is a one-party consent state. As such, the company could utilize this conversation in the investigation with the coworker's consent. North Carolina also allows recording of public common areas without sound, and the courts have not extended as reasonable an employee's expectation of privacy in an open office environment. Because Frankie was utilizing the company's computer and email network for his personal purposes, the company has a right to review those assets. But, as always, it's best to provide employees notice of your company's intent to monitor communications and assets within your employee handbook policies and to receive an acknowledgement of such.